I'm happy to introduce our speaker tonight. Benjamin Miller is a staff lawyer on the Nonprofit Law Ontario project of Community Legal Education Ontario, or Cleo. There he focuses on the legal needs of nonprofits and charities. Over the past 5 years at Cleo, Benjamin has answered hundreds of nonprofit law questions and developed an online interactive bylaw builder for the ONCA. Benjamin also works at the Ontario Nonprofit Network and previously worked at Canada Revenue Agency. Benjamin holds a JD and MPP from the University of Toronto and an MA in Political Theory from the University of Ottawa. So we're very pleased to have such an experienced and knowledgeable speaker with us here tonight. And with that, I will give it over to you, Benjamin.
Thank you very much. I'm very pleased to be here to speak to you about Ontario's Not-for-Profit Corporations Act. I'll talk about the newest elements in the ONCA, what steps nonprofits need to take to transition, and I'll give you a tour of some of the free resources that Cleo has available to you. A bit more about me before we jump in. So you heard I'm from Cleo, Community Legal Education Ontario. We're a legal aid clinic, part of Ontario's legal aid system. But in contrast to other legal aid clinics, which provide one-on-one legal services and advice, we don't do that. So nothing I say tonight will be legal advice for your organization in particular, but we do provide plain language and practical legal information on a range of topics, including landlord-tenant, employment, human rights, immigration refugee, powers of attorney and elder law, etc. So you or others in your community may need this information. So check out some of our other websites, such as stepstojustice.ca. I would be remiss if I didn't mention that this project is a partnership between Cleo and the Ontario Nonprofit Network, and that it's made possible by the generous funding of the Law Foundation of Ontario. Okay, a few disclaimers. Number one, everything tonight is general legal information, not tailored legal advice. That's not because I don't want to help. In fact, I do, but I can't because I don't have your governing documents in front of me. I don't know the history of your organization in particular. Secondly, this is intended as a high-level overview of the ONCA. It's not intended to be comprehensive. It's just an introductory session. And in fact, you'll get a survey following this session, seeing if you'd be interested in a deeper dive look at the ONCA. But you can also look at our resources and our website after this session to get more detail on everything we're going to talk about tonight. I'll also note that we're just talking about the ONCA. We're not talking about other areas of law, such as charity law. If you have questions about that, I'm happy to take them. And there will be a few places where I mention things are a bit different for charities. But by and large, we are just talking about nonprofits and nonprofit corporate law. Thirdly, this session is about law. It's not about best practices. Just because something is legal doesn't mean it's a good idea. My job is to highlight for you the options that are now available to you under the ONCA. It's your job to decide if those options are appropriate and a positive step for your organization. And then finally, this is about law. It's not about your funders' expectations, particularly when we come to the discussion of the new audit rules. There's new flexibility, but your funders, your donors may have other ideas, and they're entitled to those other ideas. But I would be remiss, you may have noticed, I have not acknowledged the land until now, and I would be remiss if I went any further without acknowledging the land, because I think doing so is vital to the lesson I want to leave you with today. So I'm coming to you from downtown Toronto, the traditional territories of the Mississaugas of the Credit, the Wendat, the Chippewa, and other Anishinaabe nations, and the Haudenosaunee. And this land has been subject for hundreds of years to the Dish with One Spoon Treaty pictured on the left. A resource sharing agreement, some refer to it as a citizenship law between the Haudenosaunee and Anishinaabe nations. Now, to explain a bit about how this law works in practice, how this treaty works in practice, you see pictured on your left what's referred to in English as a wampum belt. These belts are brought to important events with a messenger, and the belt speaks through the messenger, reiterating the terms of the relationship between the parties. Okay, keep that image of the law in mind. Now contrast that with Treaty 13, the so-called Toronto Purchase, the first attempt at which was made in 1787. By 1805, the Lieutenant Governor of then Upper Canada was so disturbed by its questionable legality that he had his staff go look for a copy. Note, he didn't know where one was. And as I've read it, they literally found a copy of it in a shed somewhere. And it was a blank deed with signatures from other pages attached. Okay, it didn't meet any legal standard. So why do I reflect on this history of the land where I find you? Well, firstly, because as somebody who actually grew up here, I knew nothing about this history and about these rules, these treaties that apply to the land where I was. And similarly, I often meet people who join nonprofits, who even join the board of nonprofits, that nonprofits with rich histories, with all kinds of rules and governance systems that have been put in place, but no one onboarded you, nobody really gave you the background, you never really saw the documents. So unless you do the research yourself, you have no clue about the rules. The second reason I tell this story about these two treaties is because I think they embody two very different ideas of how the law works. And we should, I think, in ONCA compliance, as in everything else in life, and certainly in reconciliation, aspire to the first vision rather than the second. The dish with one spoon treaty is iterative. It's fundamentally about the underlying relationships. It's brought up at important occasions. It's not just written down on a piece of paper and filed away. Contrast that with so often I meet nonprofits who treat governance as a kind of once and done process. Okay, we got our documents up to date, that's fine. The lawyer told us it was okay, we can file it away and safely ignore it for, in some cases, decades, until somebody gets nervous, asks us to pull it out, only to find that what's on paper has nothing to do with what we do in practice. So if that second story sounds much more closer to your experience than the first story, I invite us all as part of a learning process in our nonprofits and in our communities to shift our attitudes towards the meaning of law as more than just something we write down on paper to cover our bases, and to move towards how do we take the ideals that we put on paper that we claim to uphold, how do we take those ideals and actually put them into practice? That is certainly true of ONCA compliance as in other areas of law. Tonight is about getting your documents up to date. I'll point out some of the steps you may need or want to take and how to go about doing that. But what I really want to emphasize is that this is the beginning of the process. It's not the end of the process. True compliance is how you take what's in your governing documents and you actually integrate that into your ongoing practice. To make sure we're all on the same page in this learning, I want to highlight some key terms. So firstly, ONCA. What's ONCA? You're here, so I assume you have some idea. ONCA stands for Ontario's Not-for-Profit Corporations Act. It took effect on October 19th, 2021, and replaced Ontario's Corporations Act. So that was the previous statute. ONCA is a general corporate law, which means it governs things like who's a member of your organization, how big is the board, what's the voting procedure, when do you have to have meetings, what records do you need to keep, etc. That's the kind of thing it deals with. Now, ONCA only applies to provincially incorporated nonprofits. That means that if you are federally incorporated, so under the Canada Not-for-Profit Corporations Act, tonight's session doesn't apply to you. You don't need to worry about the ONCA. So you can save yourself the next hour and a bit and do something else with your evening. Maybe go outside. It doesn't apply to unincorporated associations. So if you are not currently incorporated, or you're just part of a broader organization, but you don't have your own separate legal existence, then ONCA doesn't apply to you. If you wanted to become incorporated, you could choose to incorporate under ONCA, but this session isn't for you. This is about already incorporated groups. Similarly, ONCA does not apply to business corporations, even if they operate on a nonprofit basis, and it doesn't apply to co-ops, so organizations incorporated under the Co-operative Corporations Act. So if you're under any of those categories, you can save yourself the trouble tonight. Okay, moving on to governing documents. So I mentioned tonight's about getting our governing documents ready. What do I mean by governing documents? What are the key governing documents? So the first one that ONCA affects is your letters patent. Now it's called your articles. Okay, this change in name doesn't require you to do anything. It's just a new term for the same thing. This document is a document the government would have sent you when you first became incorporated. It would say things like your address, your founding directors, your purposes, and it may include other rules if you had them added at the time of your incorporation. Generally, it doesn't include a lot of detail. Number two, your bylaws. You may not call them your bylaws. You may have another name for them, your constitution, your governing rules, etc. As the saying goes, a rose by any other name would smell as sweet. It doesn't matter what you call them. The key question is it the document you created that contains your rules of governance that ONCA expects to be put in your bylaws? These rules include things like who's a member, how does somebody stop being a member, how is voting done at members' meetings, how does notice go out to members or directors, etc. Those kinds of details will typically be found in the document that the ONCA considers your bylaws, even though you may call it something else. And it's perfectly fine to use whatever name you like. And then finally, there are policies. I use the term policies in a broad way. It could mean your code of conduct, privacy policy, your membership handbook, the list goes on and on, your meeting procedures, etc. ONCA does not have a lot to say directly about policies. Policies are more detailed and operational in nature, as opposed to the kind of high-level rules of governance that ONCA is more concerned about. So when I talk about governing documents tonight, I'm really only talking about the first two, letters, patents, and bylaws, and not really the third, policies. If you have questions about policies, I'm happy to take those questions, but assume when I talk about governing documents, I'm talking about the first two types of documents. The third area of terms I want to clarify are the key people or the key roles in your organization, because there's a lot of confusion around these concepts that I encounter on a regular basis. There are three roles I want to highlight: members, directors, and officers. And the thing I want to highlight, if you take nothing else away from this discussion, the thing I want to highlight is, although these three roles may all be the same people, your members and directors are the same people, your officers and your directors are the same people. Although they're the same people, they remain three distinct roles with three distinct sets of rules, rights, duties, obligations that apply to them. So just because it's the same people doesn't make the roles interchangeable all of a sudden. They remain distinct. What that means in practice is that, for example, members' meetings and board meetings, the way you document them, the minutes, the agendas, etc., need to remain distinct. Okay, with that preface in mind, what are these different roles? So members are to nonprofits as shareholders are to for-profits. Ultimately, the nonprofit is answerable to the members. Members have the power to elect directors. They have the power to remove directors. Ultimately, it's the members whose approval is needed to make any changes to bylaws, and we're going to talk more about that later. And member approval is needed to make changes to purposes, names, any mergers and acquisitions, any major sales of assets. So your members are very important. Although it may seem like your board is doing most of the work on a day-to-day or month-to-month basis, nevertheless, ultimately the board is answerable to the members, even if they happen to be the same people. Next come your directors. The directors are responsible for the oversight and management of the organization. If there are any staff, then they'd be responsible through the management by overseeing the staff. The buck stops with the board. The board has an obligation, and by the way, I use the term board and directors interchangeably, or board of directors. The board has the obligation to act in the best interest of the organization. As I mentioned, the board's elected by the members. Directors exercise their power collectively. They do this by passing board resolutions. Okay. Contrast this to officers. Very often, I encounter nonprofits who use the terms directors and officers interchangeably because they have a structure where all the officers are directors and all the directors are officers. While that's a perfectly acceptable structure, Directors and officers are two different things. Here are a few examples of the differences. So number one, I mentioned directors are elected by the members. Officers, by default, so that means if your governing documents don't say anything else, by default, officers are appointed by the board. Now, you can say in your bylaws that your officers are elected by the members, but if you don't say that, the default is they are appointed by the board. In contrast to directors who exercise their power collectively, officers are individuals with an individual job to do, and they have individual powers necessary to accomplish that job. So for example, the secretary who's maybe responsible for record keeping has the powers they need to keep those records. The treasurer has the power they need to oversee the finances, etc. We're going to talk a bit more about officers later. The key thing is these are different roles, though they may be the same people. If you've structured your nonprofit that way, that's perfectly fine. But even if they are the same people, the distinct roles need to be kept distinct in your governance. Okay, why care about the ONCA? You're here, so you obviously on some level care, but I acknowledge that you may have diverse reasons for caring. Some of you may be excited at the prospect of improving and renewing your governance. Some of you may just appreciate that it's, we need to remain in good stead with the law, so we need to get this done, but it's just one more thing. Some of you may be anxious or concerned that you're going to be non-compliant, and then what's the consequence of that? So for those of you who are anxious and concerned, I want to explain on this slide why you don't need to be worried. For those of you who are kind of indifferent, but you understand you need to get it done, I hope to persuade you that this can actually be a constructive experience. The ONCA transition experience can be a constructive way to improve the governance of your organization. And for those of you who are excited, I hope to give you more reasons to be excited. So here are 4 reasons to care about the ONCA. Number 1, it is indeed an opportunity to revisit your governance. If you just want to do the minimum to get it over with and get it done, we'll highlight that. But if you want to take this opportunity to, number 1, ask some fundamental questions about why it is you make decisions the way you do. Why is your governance set up the way it is, right? And ask yourself, does this still make sense for us, or did we just inherit this without really thinking about it or critically engaging it because we're so focused on the work? Then this can be a moment for you to pause and think about and learn about why your structures are the way they are and how they could be different if you feel constrained by those structures. Secondly, some new things are possible under the ONCA. I already mentioned some new flexibility when it comes to your financial review standards. There's also new flexibility in how you structure your boards, how you structure your membership. So these new opportunities for flexibility may be things you want to take advantage of to improve the way you make decisions. Number 3, your funders may ask. I've certainly spoken with some funders who have asked me about the ONCA and who are asking their fundees, whether they're in compliance, where are they in the transition process. And for them, it's really a marker that the nonprofit has its house in order. That's not a particularly inspiring reason to care about the ONCA, but it is one reason among others. And then finally, to avoid confusion later on. So ONCA took effect on October 19th, 2021. And you may have heard there's a 3-year transition period ending on October 18th, 2024. Well, that raises the question, what's happening on October 19th, 2024, right? Are nonprofits going to disappear? Are directors going to be dragged off to jail? Are there going to be fines? The answer is no. None of that dramatic stuff is going to happen. What is going to happen is the ONCA will consider most of a nonprofit's rules to automatically transition over to be ONCA compliant. The government doesn't have the power to magically change what's actually in your governing documents. So what that means is that your governing documents, if they're not compliant with ONCA, may not reflect what your actual rules are after October 19th, 2024. So if you ever have an important decision to take and people are looking to challenge it and so on, if it's not even clear what your decision-making rules are, this can create a confusing situation. So to avoid this confusion, if you take an interest sometime between now and October 19th, 2024, then you can avoid the confusion. Now, those are a few reasons to care about the ONCA. Why do I think you don't need to worry about the ONCA? As I like to say, there are many better reasons to lose sleep at night these days, right? So here are 2 reasons the ONCA doesn't have to be a reason you lose sleep. Number 1, there are no ONCA police. It's nobody's job in the government to knock on your door and ask you, have you complied with your bylaws? Number 2, it is not a major overhaul. By and large, it is recognizable to those who are familiar with their nonprofits governance systems. But there are a few things that are new. So what are those things that are new? So number 1, there's this new concept called the Public Benefit Corporation. Number 2, financial review standards. And number 3, the Ontario Business Registry, some new technology. So previously, under the Ontario Corporations Act, pretty much all nonprofits faced the same set of rules. There were a few different rules for charities, but by and large, it was a level playing field. Now, under ONCA, all nonprofits face the same rules, but then some nonprofits face some additional rules. What are those nonprofits? They're called public benefit corporations. So I'm going to discuss who is considered a public benefit corporation and what are those additional rules. So a nonprofit could come to be considered a public benefit corporation in 2 ways. If a nonprofit is a charity, then it's automatically a public benefit corporation. Okay, so that's fairly simple. If last year a nonprofit received more than $10,000 in grants or financial assistance from government, that means federal, provincial, municipal, or an agency of government like the Trillium Foundation, or it received gifts or donations from sources other than members, directors, officers, or employees. So foundations or members of the public who aren't members of the organization, right? Basically, if an organization received more than $10,000 in gifts or donations or grants from public sources, then they're public benefit corporations. The idea here is that organizations dealing with public money or organizations dealing with charitable property should face some additional rules. So what are those additional rules? There are 3 main additional rules that public benefit corporations face. So number 1, if a public benefit corporation ever dissolves, that means they end as a corporation, then they're restricted in who they can give their assets to. Now, when I say assets, I'm using that term broadly. I mean real estate, I mean equipment, I mean cash, I mean you name it, right? The way dissolution works is you have to pay off all your debts, and then if there's anything left, the question is who gets it. Now, ordinarily, a nonprofit can write what's called a dissolution clause. You may have one in your letters patent or in your bylaws, and the dissolution clause will say where the assets go. For public benefit corporations, that is not the case. There are some restrictions. Charities that are public benefit corporations can only give their assets upon dissolution to either government, that means federal, provincial, or municipal government, or an agency of government, or to registered charities with similar purposes. Public benefit corporations that are not charities can give their assets to government, federal, provincial, municipal, or an agency of government, or registered charities with similar purposes, or public benefit corporations with similar purposes. So that's rule number 1. There are limits around dissolution. Rule number 2, in general, nonprofits can have, in theory, all of their directors be employees of the organization. Again, this is where I say there's a difference between the law and best practices. I'm not saying it's a good idea. It may raise questions for your funders, for the members of the public. All I'm saying is that from an ONCA perspective, nonprofits can have, even in theory, even their entire board be employees. But there are some limits for public benefit corporations. For public benefit corporations, only up to 1/3 of their directors can be employees. For charities, it's even more restrictive. The charities can only have employees on the board if they have followed the paying directors and connected persons guide published by the public guardian and trustee. And the situations under which it's allowed are pretty limited. I'll just say that now. So this is one area where things are a bit different for charities. And then finally, public benefit corporations face a higher standard of financial review than other corporations, though even public benefit corporations in most cases enjoy more flexibility than they would have had under the previous act. So with that, let's talk about financial review standards. By default, ONCA expects all nonprofits to get an audit each and every year. Okay, that's the default. But some nonprofits have the ability to pass what's called an extraordinary resolution and waive that audit. Some of them need to get a review engagement instead. Others can waive even the review engagement. So that raises a few questions. Number one, what's an extraordinary resolution? Number two, what's a review engagement? And number three, who has this ability to waive an audit? So an extraordinary resolution. So a resolution is a motion passed by the members, and an ordinary resolution is just a 50% plus one resolution. Okay, so that's ordinary. An extraordinary resolution is a resolution that either at a members meeting gets 80% of the votes cast at that meeting. Now note, it's not 80% of all your members, it's 80% of the votes cast at the meeting. Or you can also pass an extraordinary resolution through a unanimous written resolution outside of a meeting. So if all the members who have a right to vote agree to the resolution, then you can pass it without even having a meeting. Okay, so an extraordinary resolution is what is required to waive an audit. Now, this isn't a once and done thing. It's not we pass an extraordinary resolution, then we never have to have an audit again. Nope, every year a nonprofit has to have an audit, but some nonprofits, and we'll discuss who in a bit, some nonprofits have the ability to pass this extraordinary resolution at a members meeting to, or by unanimous written resolution to waive that audit. Okay, so I mentioned that some nonprofits have the ability to waive the audit, but they have to get a review engagement. That raises the question, what's the difference between an audit and a review engagement? So an audit is where an independent chartered professional accountant comes in, looks at your source documents, your receipts, your invoices, etc., looks at your financial policies, signing authorities, that kind of thing, looks at your financial statements, your balance sheet, your cash flow, etc., and then based on all that says whether or not they can provide reasonable assurance that your nonprofit's financial statements are a reliable reflection of your nonprofit's financial position. That's an audit. A review engagement is also done by an independent chartered professional accountant, but it's faster and it's less extensive, and as a result, it's cheaper. What's the difference? So the independent chartered professional accountant comes in, looks at your source documents, looks at your financial policies, looks at your financial statements, but at the end of the day, they're telling you whether or not, after reviewing all that, your financial statements are a plausible reflection of your nonprofit's financial position. Now, plausible in this case just means that they didn't see any red flags. So at the end of the day, whether review engagement is more appropriate for your organization will vary depending on how complex your organization's finances are, whether there are risk factors, who's concerned, who's it for, etc. Every organization has to figure out for itself, even if it's eligible for a review engagement, would that be appropriate for it? And you might want to seek some financial guidance in this. I'm certainly not an accountant. Okay, so this raises the question now, who has the ability to waive the audit and maybe get a review engagement instead or waive them both? So I call your attention to the table on the screen. So nonprofits with annual revenue under 100,000. And when I use the word revenue, I'm using it in a broad sense. I mean, basically all the money you're taking in, whether it's through donations or it's through earned revenue or it's grants or what have you. Revenue is a broad term. For organizations under 100,000, they have to get an audit each and every year, but they can pass an extraordinary resolution and waive the audit, and then they don't have to get a review engagement. So they still have to present the financial statements to their members and everything, but you don't need that external review. That's for organizations under 100,000 annual revenue. For organizations between 100,000 and 500,000, it starts to matter whether or not you're a public benefit corporation. If you're a public benefit corporation, then by default, you have to get an audit, but you can waive the audit, but then you have to at least get a review engagement. Okay, that's for a public benefit corporation. If you're not a public benefit corporation, then by default, you have to get an audit, but you can waive the audit with an extraordinary resolution, and then you don't even have to get a review engagement. So again, you're still preparing financial statements, but you don't need to get that external financial review. For organizations above $500,000 in annual revenue, and I should say here, when I say annual, I mean the fiscal year, not the calendar year. Then for a public benefit corporation, you have to get an audit each and every year. You have no option to waive the audit. You have no option to pass an extraordinary resolution. If you're not a public benefit corporation with annual revenue above 500,000, then by default, you have to get an audit, but you can pass an extraordinary resolution and get a review engagement instead. Okay, now we come to the Ontario Business Registry. So when the ONCA came online, this new system came online as well. Some of you may have already interacted with it if you filed your annual information return or a notice of change or something like that. This new online system allows nonprofits to do a lot of things for themselves directly online and much quicker. For example, filing annual information returns. Previously, if you're a charity, you would have done that with your T3010, but now you do it separately. Nothing in the Ontario Business Registry replaces any of your filings for the Canada Revenue Agency. You still, if you're a charity, still have to file your T3010, your annual information return, right? It allows you to file notice of change. So if you changed addresses, if the composition of your board or officers changed, then you would have to file a notice of change, and you could do that through the Ontario Business Registry. If you want to make changes to your articles or letters patent, which you may want to or have to do as a result of ONCA, and we'll talk about that later, you can now do it through the Ontario Business Registry. Okay, I'll give more detail on this towards the end of this presentation. There are glitches throughout the system, so be mindful of that. There is a customer service line for Service Ontario. I've heard mixed reviews about the ability to get through to them. If you are encountering issues, there is a committee of the the Ontario Bar Association called OBR Info Committee, and they have an email address which I've put in the chat and which can be shared with you later. The email address is obrinfo@oba.org. So if you have concerns and you want somebody to represent them to government, this committee isn't going to give you immediate solutions, but they will make sure the government hears of what's going on, what's happening. And I will say that recently improvements were made to the Ontario Business Registry, and I do know that it was a result in part of this committee's work liaising with the government. So it's good to see that there have been improvements. Okay, so I'm going to give everybody a moment to process what we just discussed and maybe write down a few questions. And then we are going to shift gears to talk about what steps nonprofits need to take to come into compliance. Okay, so we're going to cover 6 steps that nonprofits may need to or want to take to come into compliance with the ONCA. Step number 1, figure out whether ONCA actually applies to you. So at the beginning of this presentation, I mentioned that ONCA applies to provincially incorporated nonprofits. It doesn't apply to federal nonprofits. It doesn't apply to co-ops. It doesn't apply to businesses or unincorporated groups. So I'm just reiterating that in case anybody missed that message at the beginning. What I want to add now is that if you're a nonprofit that is incorporated under a special act, which you may well be, conservation authorities, for example, fall into this category. Certain older organizations may have had an act created for them, maybe even 100 or more years ago. ONCA applies to special act corporations. The way it works is that the special act keeps applying, but then ONCA stacks on top of it. So whenever there's a conflict between ONCA and the other act wins. So your special act keeps applying, but in matters that your special act doesn't deal with, you now have rules to consider from ONCA. So let's say you've figured out that ONCA does indeed apply to you, and you're wondering, okay, when do we need to take action? So I mentioned earlier that ONCA took effect on October 19th, 2021, and there's a 3-year transition period ending on October 19th, 2024. This may raise the question for you, okay, so what are the rules that apply in the meantime, right? Like now? Well, ONCA is structured as follows. ONCA applies, it's applied since October 19th, 2021. But for those organizations that had pre-existing bylaws and constitutions and letters patent, those rules keep being valid. As long as they were valid before, they keep being valid, even if they conflict with ONCA up until October 19th, 2024. So during this period, there's kind of a bubble around your governing documents where you can look at your governing documents, and as long as you're sure they're valid, they were valid before, then you can rest assured that even if they conflict with ONCA, these are your rules. They're the relevant rules. However, let's say you're facing a situation, you want to know what's the quorum at board meetings. So you look in your bylaws, and it turns out your bylaws don't say anything about quorum at board meetings. So now ONCA applies, and so you would turn to ONCA for the answer. So that's what happens during this 3-year period. At the end of the 3-year period, I mentioned earlier that ONCA will consider most of your rules to transition over to be ONCA compliant. So that raises the question, what are these exceptions? What are the rules that won't be automatically transitioned over? So I'm going to give you 4 exceptions listed at the bottom left part of this slide. In all of these cases, ONCA expects us to move things that typically would have been put in the bylaws. ONCA wants us to move them to the articles. Remember, that's another word for letters patent. The exception here is that if we keep them in our bylaws, that's fine for now. But if we ever want to change any of these rules, we're going to have to do so in the articles. So what are the exceptions? So number 1, if we have a number of directors specified in our bylaws, so let's say it says there are 6 seats on the board. That's fine for now to have in our bylaws. It'll even outlive October 19th, 2024. But if we ever want to make changes to the size of our board, we would have to do it in the articles. It wouldn't be good enough to do it in the bylaws. Number 2, if we have multiple member classes. So members are really important, right? An organization can have more than one kind of member. Some of the members could be voting members, others could be non-voting members. There's all kinds of reasons, which if you have questions, I'm happy to discuss why a nonprofit would have these different classes. But bottom line, if you have multiple classes, 2 or more, ONCA wants those classes to be listed in the articles. But if a nonprofit has a list of different classes in the bylaws, that continues to be fine. But if you ever want to make changes to your classes and still keep it as 2 or more classes, that would have to go in the articles going forward. Similarly, the voting rights of members needs to be specified in the articles. By default, every member gets 1 vote. If you have a different structure set out in your bylaws, let's say some people are voting members, some people are non-voting members, or some people enjoy 5 votes, other people enjoy 2, other people enjoy 1, whatever, you can have that. And you can even have that in your bylaws, and as long as you don't make changes, those bylaws continue to be fine. But if you ever want to make changes, you would have to do so in your articles. And then finally, I mentioned earlier a dissolution clause, a line in your governing documents that says what happens to the property. A dissolution clause, in order to be valid going forward, needs to be in the articles. If you don't move it from your bylaws to your articles, that continues to be fine. But do keep in mind that if you're a public benefit corporation, at all times, the rules of public benefit corporations apply to you. And if your dissolution clause contradicts those, that will be invalid. Okay, so that's the window of time in which we have to act. How long does it actually take to transition to ONCA? So the estimates I've heard from lawyers who practice in this area are 6 to 12 months. And it could be longer and it could be shorter. So what are the factors that influence how long you can expect the process to take? Well, firstly, the age of the governing documents and when was the last time you changed them. If you're a very old organization and you have not looked at your governing documents in decades, it's quite likely there will be more work to do than just the minimum that the ONCA requires you to do. that is likely going to take longer. On the flip side, if you recently updated them, let's say just before ONCA took effect, and you just want to see if there have been any more recent updates, then that will be a relatively shorter turnaround. Number two, the capacity. What do I mean by capacity? Is this the first time your board is looking at your governing documents in a long time? How do they feel about governing documents? Are they anxious about them, or are they excited about them? Or is there a steep learning curve? All those things will lead to it taking longer, right? If they're anxious about the governing documents, it's quite likely they're going to procrastinate about it, right? That's human nature. We tend to procrastinate things we don't like. So doing the work of educating our boards, getting our boards to think constructively about how the bylaws can be a meaningful contribution, reminding them not to worry, there are no ONCA police, etc. All of this builds the capacity of the board and can help the process take a shorter amount of time. And not just the board, this is true also for members or committees or staff if staff are involved as well. Number three, consensus. Sometimes ONCA kicks up dust of old disagreements about things like who should be a member, what should be the size of the board, etc. Right? If there are significant disagreements on the board or among the members or between the board and the members, etc., then it can take longer to forge consensus. Now, that's not necessarily a bad thing. The time it takes to forge consensus means that the rules are more likely to be respected at the end of the day because people took part in forming them and they feel more reflected in those rules. Of course, it's not a guarantee, but it does help. But it can take longer. If everyone's already on the same page, then it can take shorter. And then finally, ease of holding members' meetings. As we're going to discuss in a few slides, the members have the final approval of any changes to the bylaws or the articles. So is it easy to hold a members meeting, or are you basically waiting until the next annual general meeting? That will obviously lead to some delays if you have to wait for the next annual general meeting. The question I get very often is, do we need to work with a lawyer? Should we work with a lawyer? If so, how? So I'll address a few of those questions. So number one, there's no legal obligation to work with a lawyer. A lawyer can add value, for example, where you have a more complicated governance structure, where there's more than one organization involved and their relationships have to be considered. If you have significant assets that might be put at risk if there's a governance dispute, then a lawyer can add value there, but there's no obligation to work with a lawyer. That's the first thing I'll note. The second thing I'll note is that working with a lawyer is never all or nothing. Sometimes it happens that people feel that they just want to get it done, right? So they hand it to the lawyer and they say, just do it for us, which could cost anywhere between $5,000 and $15,000, depending on who you're working with. So it's an expensive prospect, but it takes it off your desk. The thing I really want to emphasize is that a lawyer can put together documents that are legally compliant if they know their stuff. But what they can't do is, unless they happen to be very familiar with the culture of your organization and they happen to be very good teachers, they can't know what's necessarily realistic or appropriate for your culture. And they will not necessarily, although they might, work with you to actually build your capacity so you're able to actually understand what the rules are, why those are the rules, and how to go about following it. A lawyer cannot do that for you. Only you can do that for yourself at the end of the day. Take what's written in your document and integrate it into practice. So it's never all or nothing. The flip side of this is the more you do yourself, you'll see on Cleo's website, there are a lot of resources to help you draft and so on. The more you educate yourself, the better able you will be to narrow down what it is you actually really need from a lawyer. And that can save time and it can save money. Okay, so once you've figured out your timeline, then you need to start gathering your documents. And by the way, this is always a good idea. Again, ONCA is just an excuse maybe to get your books and records cleaned up if you didn't have them nearby. So what documents might you need? Number one, your letters patent. We already heard about that. That's the document the government first gave you when you became incorporated. What we haven't talked about yet are supplementary letters patent. If you ever made changes in the past to your letters patent, then you wouldn't get a new letters patent from the government. What you would get is called a supplementary letters patent. It's like an addendum. So you take your letters patent, you take the supplementary letters patent, you bring them together, and then you know, once you read them together, what your rules are. So you may or may not have any of these. In fact, you can order a book of all your archival documents through the Ontario Business Registry, and it costs $3, which is a pretty reasonable price. So in case you don't know, you can check through the Ontario Business Registry. Number two, your bylaws, your most up-to-date bylaws for sure, to tell you what your rules actually are. Again, you may call these your constitution or governing rules or have some other name for it, but it's where are your rules of governance. Number three, your minute books. Non-profits under ONCA are required to keep 4 kinds of minutes. Number one, board meeting minutes. Number two, board committee meeting minutes. Number three, member meeting minutes. Number four, member committee meeting minutes. Okay, those are the 4 kinds of minutes that ONCA wants us to keep. Now, I get asked, a few different questions very commonly. Number one, what about in-camera minutes? So ONCA has nothing to say directly about in-camera minutes. What ONCA does say is when it comes to your board minutes, who has a right to access them? The board. So that means all the directors, the auditor or financial reviewer, if they deem it necessary for their work, and certain court-appointed investigators or other government officials who have the power to request those documents. Those are the 3 groups of people. Noticeably absent from that list, your members. Your members have no automatic right to access your board minutes. Now, you can provide them to your members. You can put in your bylaws that the members have the right to access these minutes, but the minimum standard set out by the ONCA says that members don't have a right to access the board meeting minutes. The public doesn't, funders don't, unless there's some kind of contractual obligation that you signed on to in a funding agreement or something. Donors don't. Again, you can make these available, but you don't have to as far as ONCA is concerned. Another common question I get is, can minutes and records in general be kept virtually? The nice new thing about ONCA is that the answer is clearly yes. You can keep documents digitally, you can keep them on the cloud, that means Google Drive, OneDrive, Dropbox, etc. As long as they're available through some location in Ontario, you can keep them digitally however you like. Another common question I get is, how many years worth of minutes do we need to keep? So I hope everyone's sitting down for this. The answer is all of them. Now, I know some of you have been around for decades, probably, maybe in some cases over a century, and almost certainly you do not have all of your minutes, unless through some miracle, someone's always been that diligent and there have been no fires and so on. So the question is, if you don't have all your minutes, what do you do? So this is number one, where I remind you, there are no ONCA police, right? So how could it come up that it's a problem that you're lacking minutes? Well, it could come up in a few cases. So number one, if you did something that year that could lead to liability. So somebody got hurt, or there was a major real estate transaction or something like that, and the limitation period hasn't run out, then maybe you would want to rely on the minutes to show that the board did the due diligence and all that kind of thing. However, if the risk of litigation is low, and it's very costly to reconstruct the minutes, or maybe it's impossible. If it's impossible, at the end of the day, it's impossible, right? How else could it come up? Well, if you're a registered charity, it may be relevant to a CRA audit. The key period of time when it comes to CRA audits is the last 7 years, okay? That's a period of time that is, legislatively mandated. And if you don't have records for the last 7 years, okay, that could be an issue if there's an audit. Although the number of charities get audited each year is relatively low. Still, the law does say you are required to keep the records for the last 7 years. So that's another place it could come up. So what can you do? Well, if it's possible, you can try to reconstruct minutes, but it's essentially a cost benefits analysis or risk analysis. And if you're really concerned, this is an area where you can seek legal advice, or it may not be possible, simply may not be possible. And I acknowledge that reality, and you're by no means alone. Many organizations are in this boat. Okay, number 4, special resolutions. So we talked about ordinary resolutions earlier. We talked about extraordinary resolutions. What's a special resolution? So a special resolution is a motion passed at a members meeting that receives at least 2/3 majority of the votes cast at the meeting. So typically, if there's a special resolution, it's because some important decision was taken. Change in name, change in purposes, mergers, that kind of thing. So if you have any special resolutions, it'll be important, generally speaking, to know what they say. Directors and officers register. A nonprofit is expected to keep a list of their current and former directors and officers going back 6 years. The register should include the names, the start date, the end date, the address for service, and that doesn't mean the personal address, that means the address where that individual agreed to receive official documents, like notices of meeting, that kind of thing. The email address if the director or officer agreed to receive documents electronically, and then in the case of officers, the title, what kind of officer were they? Similarly, nonprofits are expected to keep a list of all their members, called a members register. This must be complete and go back 6 years, including current and former members, their names, their start date, their end date, their address for service, again, doesn't need to be their personal address, but it's the address where they agree to receive documents, and their email address if they agree to receive documents electronically. And if you have multiple types of members, remember that idea of multiple membership classes, what class of member were they? Director consent forms. ONCA requires that directors, so members of the board, agree in writing to be directors. This doesn't have to be a fancy form. Essentially, the essentials of the form are I so-and-so, the name of the director, agree to be a director of such and such organization, so that they agree in the name of the organization, as of X date, so their start date as director, the address of the director, and the signature, right? Now I get asked all kinds of questions. Do confidentiality forms count? Do nomination forms count? Do code of conduct count, etc. List goes on. If these documents contain the essentials I just said, then potentially they could count. But what doesn't count is the minutes of the meeting where the directors were elected, because the minutes don't typically say the director consented. What they say is that the members agreed by voting to have this person as director. So unless the document says that person consents, you don't have the proper documentation. Now, if you haven't been doing this, and you might say, well, when does it kick in? The answer is under ONCA, October 19th, 2021. So what happens if you haven't done this? Well, the answer is you can always rectify the situation. And once you get the consent in writing, then it's retroactive, as of when that director started. And then finally, it's good to know your annual revenue, because then you know maybe you're a public benefit corporation or not, or what's your financial threshold when it comes to audits and that kind of thing. It's really important to ensure that the government has the right address on file. And the way you can find this out is by going to the Ontario Business Registry and ordering what's called a profile report. If there's time at the end, I can show you how to do this. One of the changes under the new Ontario Business Registry is that the government no longer accepts a PO box as a nonprofit's address. You need to provide a physical address. Now, I certainly know that this has a disparate impact on small organizations, on rural and remote organizations that don't have reliable mail service. I know ONN has made the government aware of this. Cleo has made the government aware of this, and we continue to advocate on this point. So if you're in this situation, some typical workarounds are some community centers offer mail service to nonprofits. B, there may be some shared spaces. For example, in Toronto, we have the Center for Social Innovation. Other organizations, other towns, there are kind of shared spaces in other towns. C, you can use a director's home address if they're willing to use it. And D, accountant or lawyer's office that you work with, right? None of these are ideal solutions. There may be fees involved, but it is a requirement to have a physical address now under the new system. Okay, so now we're actually getting to the meat of what you might actually need to change or want to change. These are just some of the most common examples. Here are 5 examples of what you might need to change or want to change in your bylaws. So number 1, appointing a chair. Previously, under Ontario Corporations Act, nonprofits were required to appoint a president and a secretary. That is no longer required. Nonprofits are still welcome to have presidents and secretaries, but they don't have to. Now under ONCA, they are required to have a chair. And I am being very specific, chair, not chairperson, not co-chair, not chairman, chair. Any other name may well be rejected by the, in fact, will be rejected by the online system, unfortunately. Now, the chair has to be a director. Other officers do not have to be directors, but the chair does have to be a director. They have to be a member of the board. The chair doesn't have any special job description. They have whatever job description you give them. It's just a title somebody has to have. Okay, number 2, corporations can be members. So ONCA makes clear that individuals, corporations, and other entities can be members of a nonprofit. Interestingly, and I say this only because this is the Nature Network, it's unclear what other entities refers to. You may know that in New Zealand, there's a concept of natural bodies such as rivers having legal personhood. Whether a natural body could be a member of a nonprofit is an interesting and novel legal question that maybe one of you wants to test out. I think that would be a fascinating project for some summer law student. So reach out if you want to be connected with some law students. But the bottom line is, if you do want corporations to be members of your nonprofit, whether that be local organizations or local businesses, which you might choose to do in order to get the membership fees or to build accountability to other community organizations, then you have to actively provide for that in your governing documents. Number 3, if you have multiple membership classes, and remember, if you do, then that would have to be specified in the articles, unless you already have them in your bylaws, in which case you can keep having them in your bylaws, but if you change anything, it goes in the articles. Well, if you have multiple membership classes, you need to specify in your bylaws how to join each class, how membership in each class ends, and how to withdraw or transfer between classes. ONCA wants us to be really explicit about our rules of governance in our bylaws. So if we haven't thought through some of these things, ONCA really wants us to spell it out. Okay, number 4. ONCA introduces a number of new rights for members. One of those new rights is that members who control 10% of the votes in your nonprofit, so it's not necessarily 10% of the members, it's members who control 10% of the votes, they have the right to, in writing, demand that the board call a members' meeting. Now, there are certain circumstances under which the board doesn't have to, but generally speaking, if the members demand it, the board has to call a members' meeting. In your bylaws, you can make this threshold lower. So you can say members who control 9%, 8%, 1% have the right to demand a members' meeting, but you can't make it any higher. You can't make this right harder to exercise. You can only make it easier. If your governing documents already set out a threshold, they say, for example, members controlling 20% of the vote have the right to demand a members' meeting, then as of October 19th, 2024, that would no longer be valid. It would be replaced by this rule: members who control 10% of the vote have the right to demand a meeting. And then finally, proxy voting. Proxy voting means members have a member can't or doesn't want to attend a members meeting, so they appoint somebody else to attend on their behalf and vote on their behalf. Okay, by default under ONCA, that's not allowed. So if you want your members to have this right, you have to actively say so. What might you want to change in your articles? So number 1, your purposes. Nothing in ONCA actually requires you to change the purposes in your articles, but if this is the first time you're looking at your articles, your letters patent in many decades, you may find that your purposes are out of date. Now, if you're a charity, changing your purposes could affect your charitable status. So this may be an area to seek legal advice from someone knowledgeable in charity law. Number 2, the number of directors. So something that's new under the ONCA is that you can have a range of seats on your board. In order to have a range of seats on your board, you have to spell that out in your articles. So whether it's 9 to 12 or 5 to 15 or whatever it is, but it has to be in the articles. Number 3, If you have multiple membership classes, that has to be specified in the articles, and what their voting rights, if it deviates from one member, one vote, has to be in the articles. We already talked about that. And then number 4, if you want to restrict your nonprofit's powers. So for example, let's say you never want to sell a piece of land, right? There might be conservation reasons for that. Then it's not enough just to say that in your bylaws. For it to be legally effective, that needs to be in the articles. Okay, so that's what you might want to change. What's the actual approval process? So, disclaimer, you may have an approval process already set out in your governing documents, in which case, follow that approval process. The one thing your approval process can't change is that the members have the final say at the end of the day. Here's a default process, assuming your bylaws don't say anything else. So firstly, somebody proposes the changes to the board. It could come from directors, committee, it could come from a lawyer. If you're looking for a lawyer, Cleo's website has a directory of lawyers. We don't vet or recommend anybody, but we do confirm some part of their practice is in nonprofit law. But it could come from anyone. Once the board approves the changes to the bylaws, those changes are effective as of the board's approval. The board has the power to make changes to the bylaws unless your governing documents say otherwise, but that approval is only effective temporarily until the next members meeting. In contrast to changes to the bylaws, your board does not have the power to change the articles. The articles are only effectively changed after the government has approved them. Okay, so once the board has approved them, to make the changes to the bylaws and the articles final and official, you need to take them to the members. So there are 2 ways for members to approve the changes, either at a meeting or outside of a meeting through a unanimous written resolution. So what's required to have a valid members meeting? So first, you need to send notice. The notice needs to be sent sufficiently in advance. And ONCA says by default, notice requirement is 10 to 50 days in advance of the meeting. Your bylaws may set out another notice requirement, in which case, as long as it's above 10 days, follow that. Number 2, the notice has to contain sufficient detail to allow those who are voting to form a reasoned opinion about what they're voting on. So does that mean you send the old version and the new version? Does that mean you send a document with track changes? Does that mean you send a summary of all the changes? It depends. ONCA doesn't set out any specifics about this. What I would say, practically speaking, as someone who's been to a number of annual general meetings, is think about the person most likely to complain about the fact that they didn't receive enough detail ahead of time. How much detail do they want, right? And that's not a legal standard. That's a standard to make sure that a chunk of your meeting isn't bogged down in discussing whether or not enough detail was sent out ahead of time. That's just some practical observations. Okay, so once you've sent out the notice, and it has to be sent out individually to each member. So an Instagram blast or Facebook post, that's not good enough. Even if it's electronically, it has to be sent out individually by email, for example, to each member. So you could do a group email, but it's going to be received individually by each of the recipients. Then there's a quorum. So the members meeting has to have quorum. That's the minimum number of members required to have official business at the meeting. The default under ONCA is the default quorum is 50% plus 1 of all your voting members. Now, that may be surprising to many of you. You may find it hard to get out even 10 members. So this is where I emphasize that it is just a default. You have it. You can change this quorum to make it as low or as high as you want. Obviously, there's a trade-off in making it lower. That makes it easier to have the meeting, but then there are risks about lack of accountability and so on and so forth. Finally, you have the vote at the members meeting. So for ordinary changes to bylaws, unless your governing documents say otherwise, it's a 50% plus 1 vote, a simple majority vote. And for changes to articles, it's a 2/3 majority vote. Once your members have approved your bylaws, you're done. You don't need to file them with the Government of Ontario. If you're a registered charity, you do need to file the bylaws with the CRA, but it's not because the CRA approves them, it's just the CRA wants to have them on file. If you are not a charity, you're done as soon as your members approve them. If you're making changes to the articles, and this would be the final step, then you need to file articles of amendment in one of 3 ways. So number 1, through the Ontario Business Registry. Number 2, by downloading a form off the Ontario Forms repository and mailing it in. And number 3, through a third-party provider. There are 2, either eCor Dye & Durham or ESC Corporate Services, both of which are listed on the Ontario Business Registry website. Now, if you're using the Ontario Business Registry or mail, you're going to need to have a company key. The way you get a company key is by going to the Ontario Business Registry website. You scroll down a bit, you click order a company key, and then you fill in your information, and it gets sent to the address that the government has on file for your nonprofit. If the address you enter is different from the one the government has on file, then it's going to give you an error. So this is why it's important to make sure that the government has the right address on file. And again, you can do that by ordering a profile report off of the Ontario Business Registry. In addition to the company key, if you want to use the Ontario Business Registry, you also need a ONCA and a Service Ontario account. You may already have these, particularly if you're a transfer payment recipient. If you don't, you can create them online. It's a username and password kind of situation. The third-party provider, again, they're available through the Ontario Business Registry website. There are additional fees associated with using them. The default fee for articles of amendment is $155. What I will note about ordering a company key is that I've heard it used to be 3 to 5 weeks. Now I've heard 1 to 3 weeks to get a company key. If you order it multiple times, each time you order it, it will cancel your earlier order. So if you wait 2 weeks and then order another one, and then in a week you get one, it might be the earlier one, and it's going to be invalid because you ordered a second one. So, patience. But if it's really taking so long, you may want to get in contact with Service Ontario. Okay, so how can Cleo help? So I'm just going to very briefly give you a tour of the website. So here's the Nonprofit Law Ontario website. You can find the lawyer directory here. You can find a glossary of terms and different membership structures and pros and cons here. Transition to ONCA has more detail on everything we covered here tonight. And in particular, under Update Bylaws, you will find a number of tools, including an online interactive bylaw builder that will help you create bylaws from scratch if that's what you feel you need to do. A how to adjust existing bylaws guide, which does a side-by-side comparison of typical provisions under the old act and the new one, and sample bylaws with options. As I mentioned, we also offer a more in-depth session. So that's it from me. So we still have 20 minutes for questions. So I'm looking forward to all your questions. I will also add in the chat my email address in case anyone has questions following this presentation.
Thank you so much, Benjamin. That was great. That was really informative and really well delivered. It's something that could have been really dry, and I actually was quite interesting and helpful. So thank you very much for that. And I'm sure everybody is very grateful for all that information. And I just wanted to reiterate what Benjamin said. So he's offering to do a deep dive session. And so in the follow-up email that you get, I'll ask a question if you would attend that. So please do fill out that survey if you're interested in that deep dive session. And if there's enough interest, then we'll run that one as well.
Okay, so jumping into some of these questions. So can a review engagement resolution be passed as an ordinary annual business meeting, or does it require a special meeting? So this is a great question, and I'm not sure if this question is coming from somebody who's very closely read the Act, because the Act actually uses the language of special meeting, and it's very puzzling that it does this, and it's really unclear why it does this. Because there should be no difference. What I would say is that there's one workaround for lawyers who are particularly concerned that it really has to be a special members meeting, is they call all annual general meetings annual and special members meetings. So that's what I'll say as one practice that I know exists in the sector. But practically speaking, what I would say in general about how courts respond, there's very rarely court cases about, nonprofit corporate law, because most people don't have the money, don't have the interest, and find a way to work it out outside of court. But when things come to court and there's purely a technical deficiency that doesn't really hurt anybody, courts are very hesitant to cause a nonprofit to waste money on purely a technical deficiency. So annual versus special meeting, that's what I would say about that. But we're working on cleaning up, advocating to the government to clean up some of this language. So thank you for that question. But in practice, I think the common practice is to do it at an annual members meeting, and most lawyers I know are perfectly comfortable with that. What kind of lawyer should we be looking for when reviewing bylaws? Great question. So not all lawyers are necessarily familiar with nonprofit corporate law. So the answer is a corporate lawyer, and a corporate lawyer who has familiarity with nonprofits in particular. If you don't have familiarity with nonprofits in particular, there is a risk that they will, inappropriately import ideas from business corporate law into the nonprofit corporate context. With that being said, lawyers, they are they vary in their characters and so on. So I don't want to paint all business lawyers with a broad brush. On our website, we have a page that goes through questions you can ask a lawyer you're talking to about, what's their previous experience with nonprofits, what's their previous experience with, nonprofits of your size, because also, if a lawyer is used to governance systems that are more robust and more demanding, that may not translate well to an organization with less capacity. It's also helpful to have lawyers who are familiar with your particular subsector, so they get the language you use and why you use it and that kind of thing. Again, there are many great lawyers out there who won't necessarily tick off all those boxes. So it's really a kind of one-on-one, evaluate the lawyer in front of you kind of base decision. Our nature club doesn't have a real address, only a PO box. Previously in the old registry, we provided a director's home address that has been updated a couple of times in 40 years. Yep, so that's a very common story. And indeed, one of the downsides is, as there's turnover in directors, do you keep changing the address, or does that mail keep going to that director, right? Well, if that director keeps being friendly, that can be perfectly appropriate. But if not, it could be quite the annoyance to have to change it over so often. As I mentioned, the system is what it is at this point, and we're trying to look for alternative solutions for organizations who don't have a fixed address, but it's a work in progress. What defines a class? We have individual, family, and student members. Are they different classes? So the clearest distinction in members, and the truth is, clever drafting can go a long way to make different groups of people fit into one class. So if this is something you're interested in doing and you're retaining a lawyer anyway, this is one area where clever drafting can be very useful. But the one thing that makes absolutely clear that two different groups are two different classes is if one group has the right to vote and another group doesn't have the right to vote. That's the clearest case. Every other difference that groups of people might have, it's kind of a spectrum. It's a gray area. It depends how the bylaws are drafted, etc. But I want to address this idea of a family class, because I mentioned, who's eligible to be a member. It's an individual, it's a corporation, or another entity. Families don't really have the status of an entity. So usually the way family membership is drafted is with one or more individuals sharing a membership, or one of the individuals is the member as a representative, or multiple members have some kind of multi-member joint, but they're registered in a joint way. So that's an area where there is some thinking that needs to be done. And the type of thinking to flesh out family membership so it's consistent with the ONCA involves questions like, what happens if they disagree on how to vote? Who decides, right? How many votes? Who casts them? How do we know who the representative of the family is, right? Do we have a form to register that? If the family breaks up, who gets the membership, right? All these types of questions are questions that may follow if an organization chooses to have a family membership. When you say articles, does this refer to an organization's constitution? No, there are three types of governing documents. So number one, the articles, which is a synonym for the letters patent. This is the document that the government first sent you when you became incorporated. So it would contain things like your purposes, your original address, your founding directors, etc. Typically, an organization's constitution is a word used interchangeably with its bylaws. So it's a document that it created. It's not that the government sent it to them. That contains the rules of governance and so on. Certain special act corporations, maybe the word constitution comes up where it might be articles, but generally speaking, constitution and articles are not the same thing. Who is normally made responsible for filing the annual return with the OBR, i.e. would it be the secretary or the president? It really varies from organization to organization. If the Nature Network wanted to do a survey of its members, if people want to type in the chat, like who's responsible in your organization, it varies. From personal experience, I know as secretary on a few boards, I'm the one responsible for doing these filings, but that may just be a function of who the secretary is. So it really varies. There's no hard and fast rule. Would it be useful to use the bylaw builder even if you have them to help identify bylaws you may be missing? Yes. So the bylaw builder takes you through a series of questions. It's basically a guided interview. And so even if you don't end up using the bylaws at the end of the day, it can still be a useful experience. You'll also see, information bubbles and links and so on pop up on the side. So it can still be a helpful learning experience. The other thing is that the bylaws that it generates, you'll notice, are quite distinctive stylistically. And that's intentional. We did research literally around the world on the best stylistic elements to make bylaws as user-friendly as possible. We actually user tested the bylaws that resulted to see how fast and how likely was someone to get an accurate answer. And I've done a few tests since then, and I'm pleased to say that I do hold by the structure and style of the bylaw builder. So even if you don't end up using the bylaws at the end of the day, seeing some of the stylistic elements may give you ideas about how to make your own governing documents clearer and more user-friendly, which is another step you can take to increase the likelihood of compliance, of turning to the bylaws as a resource in the long term. Always thinking about who's your user going to be 5 years down the road, 10 years down the road, 20 years down the road, etc. Should an approval of the bylaws changes be a special resolution? So generally speaking, ordinary changes to bylaws, unless your governing documents provide otherwise, ordinary changes to bylaws are an ordinary resolution. There is a list of things that go in articles, for the most part go in articles, but some can be put in bylaws that are that require special resolution. This is section 103 of ONCA, and if you're interested, you can go to section 103 of ONCA to see this list. There are different opinions as to whether this list requires 2/3 a special resolution, even if you put those items in the bylaws. Again, tonight isn't about legal advice, so I can't weigh in to that debate. But if you want to err on the side of caution, that list of 103 would be the relevant place to start. Does your website include samples or precedent documents, articles, bylaws, etc.? So there's the default bylaws under ONCA. So ONCA has a provision that says if a nonprofit doesn't adopt any bylaws within the first 60 days of its existence, it automatically gets a certain set of bylaws. We have that set of bylaws with options of how you can vary and change that bylaws along the side of the document. So we have that, and we have the bylaw builder where you can generate templates for yourself. But I would say there's no one right answer. There's no golden solution that works for everyone. turning to organizations that are similarly situated to you, similar values, similar history, similar membership structure, philosophy, etc., such as within the Nature Network, is a great place to source other ideas about governance. I know some other networks have developed communities of practice for those boards or those EDs who want to kind of help each other through the ONCA transition process. And I know they share templates and so on through those communities of practice. So that's always an option.
It looks like that's all of the questions that are in the Q&A right now. I'll give everybody 30 more seconds. If you have one more quick question you want to type in there for Benjamin. And as I said, the recording, and as well as a few people asked, will these slides themselves be shared? And yes, we'll share those as well as the recording. And again, that survey will be in the follow-up email as well. And we can include Benjamin's email so that you can reach him in the follow-up email as well. So not seeing any other questions popping up in the Q&A. We'll just leave it there and say again, oh, there's where it popped up. Could we secure and share articles and bylaws? John, we can talk about that. Yes, we can help connect you with other groups in the Nature Network to talk about this for sure. As long as, you know, whoever's willing to share. So that's definitely an option. And if you have further questions, if that's not exactly what you're asking, then maybe you can email me separately about that. Okay, so thank you very much, Benjamin. That was really helpful. We really appreciate your time coming out on the beautiful spring evening like this and sharing this information. But I think a lot of the groups here are going to find this really helpful.
Yeah,
I appreciate
absolutely my pleasure. So I hope everyone has a constructive ONCA transition process and no one stresses too much about it, and ultimately everybody comes out better for it.
Great. And thank you, all of you, for coming out and spending your time to listen to this and getting your own house in order. And yeah, hope that you found it helpful, and reach out if you have any further questions.